Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 79 of the NCDWI Guy podcast. On today's episode, we are talking about the community caretaking exception to the warrant requirement. How exciting is that? Community caretaking, right? This is something we actually see a lot in practice. This is argued a lot by the state. It's either community caretaking or some sort of consensual encounter argument that you see frequently when there is no reasonable articulable suspicion by the officer to stop. They have to resort to some other type of allowed interaction. And so a lot of times you see consent or the community caretaking doctrine being argued by the officer and ultimately by the prosecutor, by the state. So this is something that I think we will see a lot in practice if you regularly handle DWI cases. Before we dive into today's content, exciting announcement. Attorney James Davis has just released the newest edition of his DWI Trial Notebook. This is something that I have recommended in our resources episode of the podcast. This notebook is incredibly helpful if you are a DWI lawyer in North Carolina. The DWI Trial Notebook, a primer for the North Carolina practitioner, is published by James Davis. It's available on his website. If you look under the profile page, under his profile page, you will find this resource, and it is an incredible resource. So if you go to davislawfirmnc.com and you go to about the firm, attorneys and staff, you'll find James listed there first under the directory. Go to his profile page, and at the bottom you will find all of the different resources that he's published, including the trial notebook. And this thing is literally hot off the press. I think that it will actually technically be released the same day that this episode is getting released. So it is fresh off the press. And I am supporting this because this is a great resource for case law, for statutes on DWI topics, DWI related issues in North Carolina. And I stole a couple of cases for today's episode from this resource as we're talking about the community caretaking doctrine. So again, really helpful, powerful resource. If you regularly handle DWI cases, go check out the DWI Trial Notebook by James Davis. So diving into today's episode, we have a couple of cases that we are going to look at in terms of this community caretaking exception. And again, it's important to understand, when is this being used by the state? So basically, the state is using the community caretaking exception to the warrant requirement in a traffic stop that is not supported by probable cause or reasonable suspicion to believe that a crime is occurring. So if there's reasonable suspicion to stop, if there's probable cause to stop, the state is likely not going to argue the community caretaking function. But if there is no reasonable suspicion to stop a vehicle or to investigate a parked vehicle, then the state may argue the community caretaking exception to the warrant requirement. And this exception was laid out in State versus Smathers, a 2014 case local to where I am. This is out of Transylvania County, and this is a case that lays out and adopts the community caretaking exception. So State versus Smathers is the site is 232 NC App 120, is a case where North Carolina adopts the community caretaking exception. And the court points to the fact that this is an exception that was recognized by the United States Supreme Court. So this is built off of the United States Supreme Court. If you want that site, it is Katie versus Dombrowski 413 US 433. That's where the community caretaking exception was established by the U.S. Supreme Court. And then there have been a number of districts or different states that have adopted some form of the community caretaking exception. Some of them use balancing tests. Some require that a person be in serious danger, that their life be in serious danger in order for the community caretaking exception to apply. So the Smathers court does a good job of kind of going through all of the history related to the community caretaking exception, how it developed. But ultimately, it basically lays out a three-part test for the community caretaking exception, and then adopts a balancing test in weighing those factors. So here's the community caretaking exception that is established by Smathers. The state has the burden of proving three things in a community caretaking case. First of all, that a search or seizure within the meaning of the Fourth Amendment has occurred. Search or seizure within the meaning of a Fourth Amendment has occurred. So again, you really can't argue both community caretaking and consent, because in order to establish the community caretaking exception, you have to argue that a search or seizure of a person has occurred. So this is not an analysis that is kind of going along with a consent analysis. So that's number one. Second, and each of these three things that the state has to prove build on one another. So only if you find number one can you move on to number two. Only if you find one and two can you move on to number three. So first, a search or seizure within the meaning of the Fourth Amendment has occurred. If it has, then two, that under the totality of the circumstances, an objectively reasonable basis for a community caretaking function is shown. And three, if that's happened, if both one and two are met, three, that the public need or interest outweighs the intrusion upon the privacy of the individual. So again, you only move on from 1 to 2 and from 1 and 2 to 3. You've got to have 1 in order to get to 2. You've got to have 1 and 2 to get to 3. And the reason that that's important, you're generally not going to probably have an issue with 1, whether or not there was a search or seizure. Again, unless the state is trying to kind of argue also consent. And then you can say, well, the state just argued consent. You don't get to number 1 because the state just characterized this as a consensual encounter. But in most cases where community caretaking is going to be argued, number 1 is going to apply. But it's important to determine if number 2 is present so that you ultimately, hopefully, do not have to get to the balancing test that will be performed under number 3. So again, the third thing that the state has to prove is that the public need or interest outweigh the intrusion upon the privacy of the individual. The court in Smathers basically laid out a 4-part balancing test to look at the third item that the state has the burden of proving when it comes to community caretaking. And so these are the considerations that need to be used when assessing the public interest against the intrusion on privacy. Number 1, the degree of the public interest and the exigency of the situation. Number 2, the attendant circumstances surrounding the seizure, including time, location, the degree of overt authority and force displayed. Number 3, whether an automobile is involved. And 4, the availability, feasibility, and effectiveness of alternatives to the type of intrusion actually accomplished. So we have this balancing tests, and balancing tests are generally not in favor of the defense, right? I mean, this is something that balancing is not something that I like to have to argue. And so that is part of the reason why, if you can avoid getting to prong number 3 and take the balancing out of the court's hands and basically say, Judge, you only get to use the balancing test if numbers 1 and 2 have been met. And then under 3 is when the balancing test comes in. That's where the attack is strongest. And so most of these community caretaking arguments or challenges, the defense should be hammering that the state hasn't proven any of these 3 things, but specifically number 2. And that is that under the totality of the circumstances, an objectively reasonable basis for a community caretaking function is shown. If there's not an objectively reasonable basis for the community caretaking function, you don't get to the balancing test. You don't get to determine whether the public need outweighs the individual intrusion. So if you can attack it at point 2, you have a much stronger ability to be successful on this issue. It's really important to try to attack it at number 2. The other thing that you want to use from Smathers is some of the language from Smathers. So Smathers ultimately finds that the community caretaking exception was appropriate in this particular case, and we'll talk briefly about the facts of Smathers. But there is some good language from Smathers that you can use in your legal argument when it comes to attacking the community caretaking exception. And that language that I'd like to focus in on is this. We agree with the proposition espoused by many courts that this exception should be applied narrowly and carefully to mitigate the risk of abuse. So when you start an argument based on the community caretaking exception, you want to do 3 things. First of all, you want to point out who the burden of proof is on. It's on the state. Secondly, you need to point out what the state has to prove. So the 3 things that we just talked about. And then third, you want to point out that the Smathers court and all of the other cases have pretty much referenced this language that we're going to talk about today. The language from Smathers that we agree with the proposition espoused by many courts that this exception should be applied narrowly and carefully to mitigate the risk of abuse. You want to remind the court of that, because if the officer just has to say, I just pulled this person over to check on them, and that's it, then there's a problem with this exception, right? Just wanted to pull them over and make sure they knew where they were going. Just wanted to pull them over and make sure that everybody was okay, right? There's got to be an end to the ability for the state to intrude into an individual's life. And so if you can focus the court on that language, which is echoed through many of these other North Carolina cases, that this exception, the community caretaking exception, should be applied narrowly and carefully to mitigate the risk of abuse. This is a narrow exception, Judge. Very small window of cases should fit into this particular exception. Remind the court of that. So in Smathers, ultimately the court found that the state met all 3 prongs of the test, that the state had proven those. In looking at the facts of Smathers, the defendant in that case was traveling at speeds close to the posted speed limit of 45 miles per hour. And the officer did not observe anything illegal or suspicious about the defendant's driving. The officer, as he was following the defendant, saw a large animal run out in front of the defendant's vehicle. The defendant struck the animal, causing her vehicle to bounce and produce sparks as it scraped the road. And then after that, the defendant decreased her speed to 35 miles an hour, and the officer activated blue lights. The defendant didn't immediately stop. Officer turned on lights and siren. The defendant continued for about 1.1 to 1.2 miles. The court specifically noted in this case, in terms of the balancing test that it performed under prong 3 of what the state had to prove, that this was a stop that occurred at nighttime and that it occurred on a rural country dimly lit stretch of road. So there was a lower probability, according to the court, that the defendant could have gotten help from someone else if she needed it, especially when you compare it to a similar collision occurring during the day in a highly populated area. The court said, yeah, there could be problems with being able to get help because of the time and location of the stop. Moreover, the court noted that specifically the defendant struck a large animal with her vehicle and saw sparks when the car bounced on the road. Therefore, he was able to identify specific facts, which led him to believe that help may have been needed rather than a general sense that something was wrong. So the court focused on where this happened, what was going on, and then the specific facts that would believe that there was a need for help as opposed to a general sense that something was wrong. So point that out to the court in your case if that's applicable, whether or not there is just a general sense that something is wrong, or if there are specific facts as to why the officer is getting involved, right? So just to give you a couple examples of this, just outside of any specific case law. And again, it doesn't mean that the additional facts might make this go one way or the other. But if you have a vehicle that is sitting with its lights on a street, parked on the side of a street, and is just sitting there, car running, that is a different situation than a vehicle that is on the side of the highway that looks like it's been in an accident with its emergency lights on, right? Very different scenarios. In the one scenario, the officer could say, appeared that this vehicle had been in an accident, that the vehicle had its emergency flashers on, maybe indicating that help was necessary. And so those are specific facts that lead to believe that the person needs help, versus a general sense that something is wrong when I see a vehicle parked on a city street with its lights on, car running, nothing else going on. Again, additional facts in both of these situations may change what the court might want to do, but it's important to note that a general sense that something is wrong is not sufficient in terms of the balancing part of the analysis that was done under Smathers. So a couple of other cases to point out. One, State versus Brown. This was a case that I mentioned in the 2021 DWI update episode that we did. That was back on episode 66 of the podcast. We talked about this case, so I won't get too much in the weeds on this one, but I think the facts are helpful. So State versus Brown was decided in 2019. The citation for State versus Brown is 265 NC App 50. And in that case, there was a couple of officers that were sitting in a parking lot of a gas station that was closed. So the business was closed. They're sitting in the gas station parking lot outside their vehicles. They hear defendant's vehicle approach, and the words MFer coming from inside the vehicle. I won't curse. Never know if people have kids in the car when they're listening to this. So I won't say the full language that came out. But basically, this vehicle is traveling by the gas station. The officers hear MFer yelled from the vehicle. The officer testified he knew it was coming from the vehicle because there was no other vehicles on the roadway and nobody else around. There was no other open businesses, according to the officers, either stretch of the roadway for several miles. So in either direction, there was no other businesses open. So again, when you look at this compared to Smathers, we have a rural country road. We have nighttime. This occurred in Brown at around 3 o'clock in the morning. So you can distinguish if your case is on a rural country road at nighttime. You can still distinguish from Smathers because the Brown court ultimately found that there was not an appropriate use of the community caretaking function. And the reason why is because they never got to the balancing test. But you can point out the facts in Smathers were that this was a rural road and that this was 3 o'clock in the morning, if that's going to be helpful to you. The court in Brown ultimately said we never get to the balancing part of the test because under prong number 2 of the analysis, under the second part of the community caretaking analysis, we do not think the totality of the circumstances established an objectively reasonable basis for a community caretaking function to exist. And again, you don't move on to the balancing test unless you've established that objectively reasonable basis for the community caretaking function. So the court said, we don't see that somebody screaming MFer from the car is enough for a stop, a kind of community caretaking, a helpful policing stop. The court said that the deputy did not know if the driver or a passenger yelled the words, did not know if there were passengers in the vehicle, did not know if the windows on the vehicle were up or down, and did not know who the words were directed towards. The deputy acknowledged that it could be directed towards us. It could be a sign of people inside the vehicle fighting. It could have been somebody on the telephone. There are multiple scenarios with that. Okay, so it said we believe that could be any number of different things that could have been going on in that. And again, that leads really just to a general sense that something is wrong. There's not enough specificity as to why somebody needs help. That's where that fails, right? It does not give that specificity. So again, the court said you never get past the second thing that the state needs to prove when looking at the community caretaking doctrine, which is that the totality of the circumstances established an objectively reasonable basis for a community caretaking function. You got to have somebody that needs help. Got to have somebody that needs help, right? So if you have somebody that does not need help, you can't specify why this person needs help, you can't get past that second prong. You can't get past the second part of the analysis. The final case that I will reference briefly is State versus Hudi. This is 253 NCAP 148, 2017 case. And in this case, the court said you don't get to use the community caretaking exception in a situation where a vehicle is in one's driveway with its doors open. And that's the basis for there to be a community caretaking exception. That's not enough. So again, not a ton of, you wouldn't expect the community caretaking exception to be found in that situation. The court looked at some other issues related to Fourth Amendment law in that case. But again, another North Carolina case that says this does not create the community caretaking exception. So look at Smathers. Look closely at Smathers in terms of what is the burden of proof. What is the three things that the state needs to prove? Know that they build on one another, that you don't get to part 2 that the state needs to prove until state has proved part 1. You don't get to part 3 until the state has proven parts 1 and 2. And then understand what factors are being used. If you get to part 3, what factors are being used to balance the public interest against the individual privacy expectation. Look at those balancing factors that are laid out in Smathers. Then remember always to argue to the court that this is a narrow exception that should not be used to create a lot of leeway for officers when it comes to search and seizure. This is something that needs to be narrowly applied in order to avoid the risk of abuse. Hammer that point. Look at State versus Hudi and State versus Brown. Point to the court that there have been recent cases where the court has not found the community caretaking exception was appropriate, and then ask the officer and ask the court what made this situation get to a point of being beyond just a general sense that something is wrong. So again, look at State versus Smathers, State versus Hudi, State versus Brown. Understand the layout of your argument, apply the facts to that argument, and I look forward to seeing you next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.